charge related to a toddler, a 2-year-old child, who was in his care at the time the child became unresponsive and died away based on what medical service providers refer to as traumatic injury. This trauma was extensive, and there were bruises about the child's body. I can't advise you, of course, what the ultimate cause of death was, but there were some alarming findings, including fractured ribs, severed liver, and some internal injuries of the sort. There was indication that there may have been head trauma, but I cannot confirm that that was the cause of death at this point. It is alarming under Rule 46 to consider the defendant's violent criminal history in conjunction with the allegations that this child was beaten to death, essentially, or reduced to the point that his body could no longer take it. He's in domestic violence court at the moment. That is based on a 2019 criminal conviction that is not related to the mother of the child who passed away today. That was late last year. That was related to a different romantic interest from 2019. While in the supervision of the Ada County Domestic Violence and while undergoing those rehabilitative efforts, it appears that his risk of violence was not attenuated in this particular case. He's living at a home in Garden City that has been paid for by his parents. That will become crucial when we talk about the appropriate amount for bond, given the financial support that he receives from his parents and the parent residence that they own and allow him to use. His girlfriend, the victim's mother, was living there with the victim there at the defense. She's pregnant with the defendant's child. There was also another child, a 5-year-old, who is the defendant by way of a separate relationship, not the domestic violence victim and not the victim's mother in this case, who resides periodically there with the defendant in this Garden City address. The state's request under Rule 46 is substantiated primarily by concern for protection of the community, the defendant's violent criminal conviction in conjunction with the violence visited upon the child. In this case, they're of concern. I won't belabor the facts of the case of the investigation, except to say that ultimately the defendant has made admissions to visiting violence upon the child and losing his cool or losing his patience with the victim. That plays into the factor of continuing threat in the community if he's released on a bond that does not in some way deter his future conduct. The state's request is also based on the nature of this case. Murder in the first degree as a result of an aggravated battery on a 2-year-old there's no way to say it except that it is significant. The defendant must be contained and was not contained by virtue of his probation status and domestic violence-related conviction. As a result of all of these things, when we take in totality the risk that he poses to minors in the community when he becomes enraged or frustrated, as well as the damage that he visited upon the child, in this case a 2-year-old in his care, and his access to substantial assets, including a home that was apparently provided to him by his parents. The state's request is for a $3 million bond in this case. I do request also a no-contact order between the defendant, the victim's mother, Ms. Scott, as well as all minor children. The court will find in my proposed order that I've requested that he not be permitted to be within 20 feet of children. Should he be able to post this $3 million bond, the state has no illusion that he won't at some point be around a child, but the 20-foot restriction should prevent him from being the sole care provider or custody provider for any child, including his own. The state feels that those two measures, the $3 million bond and the no contact order, are what's required to protect the community and to assure the
All right. A couple questions. The proposed protected person in the no contact order, is that person the victim in the case that's in the domestic violence court?
No, and I apologize. The if I wasn't clear, she is the mother of the child victim at issue here. The victim in the domestic violence court is a former relationship. That victim is also not the mother of the 5-year-old child over whom the defendant has periodic custody and was also living at the Garden City address on the day of the incident.
All right. Mr. Ralston, Mr. Williams.
Your Honor, needless to say, the charges are very serious. However, I do think a $3 million bond is grossly excessive. Mr. Williams does not have a particularly violent background, as portrayed by the state. He does have a misdemeanor domestic violence case. My understanding, he's been on probation for that for quite some time and is progressing well on that. Other than that, he has a almost extremely minor record. He's 30 years old, born in Arizona, moved here with his parents when he was about 2 years old, lived here for about 28 years. His local situation is extremely stable. He owns his own home. He's on the mortgage with his parents. Frankly, I see that as just the opposite. I don't see that being held against him for a higher bond. It just shows his stability in the area. He very much would like to at least be allowed phone contact with his 5-year-old son. That'd be very important with him. So if there is a no contact order, we'd ask that he at least can talk to his son on the phone. He's an apprentice electrician. That's a very good job, leading to a extremely good career track. Despite his minor record, he has no failures to fear. His parents, as stated before, both of his parents live here, the co-owners of the home that he lives in. So risk of flight is basically non-existent. I don't believe he's a danger to the community of any kind. Whatever happened here is situational. If there's a no contact order with children, this is a situation that just can't occur. At 30 years of age, he has very minimal record at all, extremely close ties to the community, stable, very stable situation. We'd ask the court to consider a fairly low bond, maybe something in the $25,000 to $50,000 level. Pretrial release conditions are certainly appropriate. No contact conditions are certainly appropriate. Well, as we said before, we'd ask that he can at least have some phone contact with his son and maybe some supervised contact. Certainly very serious charges, but his ties to the community are immense. His stability, lack of significant record are significant. So we'd ask the court consider a much lower bond. Thank you.
All right. Would the parties agree that no bond is an option in this case as well on a first-degree murder charge?
It is an option.
Under Idaho law. Yeah, I mean, I thought that there doesn't have to be a death penalty element indicated by the state in order to make that true. All right, I'm going to do this. I'm going to decline to enter the no contact order. I am going to direct that Mr. Williams be held without bond. However, for the preliminary hearing for March the 4th at 8:30 in front of Judge Vale, and then Judge Deborah Vale will be the district judge at that time. Thank you, sir. You're excused.
I have one question on the no contact order. Is the court declining it against the child's mother as well?
Yes, I don't think there was a nexus with the mother on this, but with the no bond spouse, I don't believe there's a risk of the safety of the people involved, so I don't think it's necessary at this point.
The piece that I had in my notes that perhaps I failed to articulate is that she's pregnant with the defendant's child at this point.
All right, but again, because of the no bond situation, I don't believe it's necessary at this point.
All right, sir. Thank you.
Thank you.